Hi friends, welcome to Immigration News by Ting Law. I'm your host, John Ting. My law firm, Ting Law Group, we practice immigration law and represent clients all across the world in all 50 states of America. Now, today we're going to talk about the public charge rule. That pesky old rule that was supposed to take effect in October 2019 has now come to the news on the forefront this past Monday, November 2nd. You know, this past week has been very hectic with the election week. On October 2nd, the federal district court judge in Chicago, Illinois, he actually vacated the public charge rule. Now, keep in mind, the district court is a trial court, essentially, of the federal level. So the next level is appellate court. Now, let me tell you why this judge vacated the rule. He found it unlawful because of three reasons. Number one, he said that it exceeded Department of Homeland Security's authority to implement this expanded public charge rule. Number two, he found it arbitrary and capricious, meaning that it violated the Administrative Procedures Act. It's just a process of how the rule has to be created and have a comment period as well. And number three, he found it not in accordance of law. In addition to those three reasons, this judge also found that the public charge expansion rule violated the equal protection component of the Fifth Amendment's due process clause. Now, this has been back and forth. The plaintiffs in this case, who are in favor of the immigrants, have moved for summary judgment, meaning asking the judge to make a final decision on the case without having to go into more detail like an actual trial. The judge, based on the motion for summary judgment, actually granted it because his order stated that he basically felt more comfortable in the sense that the Seventh Circuit, which covers Illinois, also granted a preliminary injunction in favor of the plaintiffs. And that was back in June, stating that the Department of Homeland Security did not consider the reliance on the state government, and also it did not consider the 5-year waiting period for some of those benefits. So that was back in June in terms of the Seventh Circuit allowing the preliminary injunction. So it's gone back and forth. Although the Department of Homeland Security moved to dismiss the case, the court denied that request. And during the plaintiff's motion for summary judgment, the Department of Homeland Security conceded to the Seventh Circuit's affirmation of the preliminary injunction, which resolves the claim against the violation of the Administrative Procedures Act. The Department of Homeland Security, knowing that this is going to happen, that the judge was going to vacate the expanded public charge rule, the department asked the judge if they could just keep it vacated just for Illinois, the state of Illinois. But the judge, Fenderman, actually made it nationwide. So what does this all really mean to you as an applicant applying for immigration benefit? At least as of November 2nd, on Monday, you would not have had to apply for the I-944 form for the public charge specifically, and that you would not have to provide, for example, not only your bank statements, but also your petitioner's bank statements, or even your credit history, your petitioner or your citizen spouse's credit history, among other things. But things changed. It's a different day. So let me update you about the current situation. But that was what happened on Monday, November 2nd. Now, November 3rd is the following day, and the appellants, which is the Department of Homeland Security, requested a stay to the next level, the appellate level, called the Seventh Circuit Court of Appeals. And they actually granted the stay, meaning that whatever the judge at the district level ordered, which was to vacate the rule, the Seventh Circuit said that order is not going to happen. So it basically is trying to say, keep the status quo until there's another hearing. So it's really gone back and forth. So I know this is frustrating to anyone that applying for immigration benefit right now. My suggestion to anyone trying to apply is that despite all these different lawsuits, because there's several across the country, not just this one we're talking about, Cook County versus DHS, I recommend preparing the 944 form and gathering that evidence anyway, because you just never know when you'll need it. It's better to be prepared. So as of now, the public charge expansion still stands. If you have any questions about this in more detail, please schedule an appointment with us. If it's a more generic question, you're welcome to post that as a comment to our YouTube channel, So continue preparing your 944 form and gathering that evidence, because despite what's going on in terms of this case in court, the appellate court, what the appellees have to do, which is the plaintiffs, they have to file a response by November 17th. Their responses don't affect you. You still need to prepare that form and that evidence. Now, because it's election week, I thought I would take a moment to answer some of the questions I've had from the public and what I think will happen if Vice President Biden becomes the next president of the United States as it relates to this rule. Of course, there's many other things to discuss about immigration, but I think he will just vacate this rule, basically reverse this rule, delete it from existence, because especially when there's so much litigation going on. But could there be an expansion of the public charge rule in the future? I think there could be. It's not, because in general, it's very vague right now. It's difficult for USCIS officers to even make a determination that someone is a public charge and cannot immigrate into the United States. So it's not as clear cut anyway, but I don't believe that is on the top of his list in terms of priority on changes for immigrants. If you like this content, please hit subscribe so you get the future notifications. Hit the like button. It really lets us know that we're sharing great content for you in a short segment. That's our goal.